Good evening. I'm Nathaniel Stevens. I'm a financial advisor at Wright-Patt Credit Union and work in conjunction with QSO Financial Services. And we're going to be talking tonight about estate planning, specifically estate planning basics, which is an overview of the estate planning process. A little bit of information about me there. First and foremost, it helps to define what is an estate plan. An estate plan is a map. It's helpful to think of it that way, and that map reflects, as it says on the slide, the way you want your personal and financial affairs to be handled in the case of incapacity or death. And I like to point that out. Incapacity is an important piece of this because we don't often think of that. We think of an estate plan as being planning for one's demise. But those situations where you become incapacitated are just as, or sometimes even more important. So who needs an estate plan? Chances are, of course, you do. You may think estate planning is just for the wealthy, but it's not. In fact, an estate plan is actually more important if you have a smaller estate because your final expenses will, of course, have a much greater impact on your overall finances and the estate that you leave behind to your beneficiaries. There's a much greater possibility that your loved ones could suffer if they don't have availability of those financial resources. And of course, without an estate plan, you give up any control that you have for what happens to your property if you were to die or become incapacitated. Generally, people create estate plans because they want that control. That's typically what it's about. They want to make sure that their wishes are clear in order to avoid any conflicts with their family or other loved ones. And they want to make sure that they preserve that property for the use of their loved ones and it doesn't go to lawsuits and fees and things like that. An estate plan is especially important if your spouse isn't comfortable with financial matters. You have young children who would need a guardian. You have an estate that would be impacted by transfer taxes. So, as it notes here, and we'll talk about this a little bit more here in the future, but on the federal level, that's estates that are over $11.7 million. On the state level, I'll go ahead and let you know now, the state of Ohio repealed the estate tax about, I want to say 8 or 9 years ago. So that is not a concern if you die in the state of Ohio. If you own property in more than one state, an estate plan is especially important. If financial privacy is important to you, or if you own a business, these are particular scenarios where it makes sense to make sure that you have an estate plan in place. These are the estate planning concepts that we'll be talking about this evening. We'll talk about planning for incapacity, healthcare issues, property management issues. And then we're going to talk about planning for death, which I mentioned is the one thing that most people think about when they think about an estate plan. We'll focus on wills and probate, the basics of taxes. Obviously, taxes are a very complex topic when it comes to this. So the basics of taxes we'll dive into. Lifetime gifting, a little bit about life insurance, and lastly, a little bit about trusts. So planning for incapacity. Incapacity describes a condition in which you are unable to make your own decisions. So this can happen for a number of reasons, but typically it is medical. We're talking about planning for incapacity because it could happen to anyone at any time. Think for a moment what would happen if you were to become the victim of an accident and were to be in a coma for a period of time. How would your doctor know what medical treatments you want or don't want if you can't speak for yourself? How would your personal business be transacted? Meaning, how does the electric bill get paid at home and your property taxes and so on and so forth? What would happen is someone would have to go to court, typically a relative, and they would have to get legal permission to act on your behalf. That person is called a guardian, and they're usually a close family member, such as a spouse or a child. They would also have to go back to court every time they want to do something in order to get permission from the court in order to move forward with that decision. Without any prepared instructions, it can be really burdensome. So let's talk about healthcare directives first. This is where you leave instructions about the medical care that you would want if conditions were such that you couldn't express your own wishes. There are three different ways to do this: with a living will, a durable power of attorney for healthcare, which is referred to as a healthcare proxy in some states, but in the state of Ohio, it's a durable power of attorney for healthcare, and a do not resuscitate order, or a DNR as it's commonly called. A living will is a document that lists the type of medical treatment you would want or not want under particular circumstances. For example, your living will might state that you would not want life support if you fell into a persistent vegetative state. With a living will, you have to think about all the possible scenarios where you would want a specific action to be taken and put your wishes into writing so that the reader will understand them. A durable power of attorney for healthcare or a healthcare proxy lets one or more family members or other trusted individuals make medical decisions for you. Unlike a living will, with this type of healthcare directive, you don't have to envision a specific circumstance. You simply grant your agent or agents the right to make those decisions for you. So let me give you an example. You could put in your living will specific situations like if you've got a disease and you know that it can cause some type of incapacitating, hard to recover from condition, you can say, if this happens to me, these are the decisions that I want made. But in any other situation that's not spelled out specifically in the living will, your healthcare proxy or that person who is labeled as the power of attorney under your durable healthcare power of attorney would make those decisions on your behalf. So, whomever you list as your power of attorney under your durable healthcare power of attorney, you want to make sure you have a conversation with them so they know what types of decisions you would like made, and make sure it's someone that knows you well and that you can trust. A do not resuscitate order, or a DNR, is used for a different purpose. So let's say you're in the hospital, you're suffering with a terminal illness, and you don't want the hospital staff to take life-saving measures if you suddenly were to go into cardiac or respiratory arrest. To make sure that your wishes are carried out, you may be able to get your doctor to issue a DNR. It's a legal form signed by you and your doctor that's posted on your bed to give staff members the permission they need to carry out your wishes. However, you want to be careful when using a DNR because some states require their own, and some states require a DNR form for the hospital and a separate, different DNR form for a nursing home. Also be aware that some states don't recognize healthcare directives at all. So depending on the state, you may need one, two, or all three of them. But the state of Ohio recognizes all three of these. Now let's take a look at property management. So the thing that we were looking at just a minute ago is taking care of you. This is taking care of your stuff. So there are three ways you can plan to have your financial affairs taken care of for you in the event that you would become incapacitated. You can arrange to own property jointly. You can appoint an agent using a durable power of attorney, or you can create and put property into a trust, a living trust as it's called, and name someone to take over the management of that trust if something were to happen to you. Granting joint ownership of your property to another person allows that person to have the same access to the property as you do. If you become incapacitated, the joint owner simply continues to act with that property as if it were theirs, because in fact it is. If you and your spouse have a joint checking account and one of you becomes incapacitated, the other can just continue transacting business and writing checks just like they always had. So if you were to go into a coma, that person who owns it jointly with you would be able to continue to carry on. One caution on joint ownership is that it is exactly what it sounds like. If you make someone a joint owner on your checking account or your savings account or any other piece of property, you are effectively gifting them the property. They can walk into the bank and take all the money out, and there's nothing you can do about it. So obviously with a spouse, you're probably not too concerned about that. But if it's someone who's not a related person to you, you want to make sure that you understand what that means, because you are effectively transferring ownership to that person in addition to yourself. A durable power of attorney lets you name a family member or anyone else, any trusted individual, to make financial decisions or transact business on your behalf. So it's just like the durable power of attorney for healthcare, only again, this is for your stuff. So, and also, I'll make another side note here on the durable power of attorney. You can also list specific circumstances. So you can say things like they can write checks out of my checking account to pay bills, but they're not allowed to buy or sell stocks and bonds, or they can't transact real estate on my behalf, or maybe they can. You can spell all of that out specifically, according to what your wishes would be in the event something like that would happen. And in addition, of course, to joint ownership and a durable power of attorney, using a living trust is another common strategy. Now, we're going to get into trusts in a little more detail later. I mentioned that at the beginning. Just know that a living trust can be used to plan for incapacity because someone who's called a successor trustee can step into your shoes in the event that you are unable to make decisions on your own behalf. Now, What happens if you die and don't have an estate plan? All of us make plans that are based on the possibility that a specific event may occur, right? That's what this whole thing is about. Many of us carry more than the required minimum for auto insurance because we recognize that loss could result from an accident if someone is injured or so on and so forth. Since it's 100% certain that each of us is going to die at some point, you might think everyone would have an estate plan. However, you would be sorely mistaken. So, what happens if you die without an estate plan? If you own property jointly, that property would pass automatically to your joint owner. So if you remember that conversation we just had about joint ownership of a checking account, for instance, if you and your spouse own a checking account jointly, your spouse passes away, that account is still yours and you can continue to transact business. It just passes along smoothly. If you have an IRA or a retirement plan or you own life insurance and you have named beneficiaries on those, the funds would pass automatically to your designated beneficiaries when you die. Also, property held in a trust would pass automatically to designated beneficiaries when you were to pass away. In general, however, if you pass away and don't have an estate plan, property will pass according to state intestacy laws. The laws govern the disposition of property when someone dies without a will or with a will that doesn't account for a portion of the estate. So let's say you die and you leave $5,000 in the savings account. Who does that money go to? Without instructions from you, the money would go to the person or people that your state's intestacy laws say it should go to. Intestacy laws vary state by state. Here you can see they put on the slide a typical pattern of distribution. Now, in the state of Ohio, it actually does not pass quite this way. So I'll kind of diverge a little bit here and talk a little bit about the state of Ohio. In the state of Ohio, if you are married, all of your assets simply go to your spouse. If you are not married and you have children, your assets will pass to your children. If you are not married and don't have children, they will go to a sibling. If you are not married, don't have children, and don't have a sibling, they'll go to your parents. And if you don't have any of those people, that's when the court will decide who gets that money. Um, Now it gets a little bit more complicated if you're married and you have children from another marriage and things like that. Then the state does lay out some details for that. And if that's a situation that you end up in, your heirs will find out what those are. The ideal goal, of course, and the reason that we're here tonight is to make sure that this doesn't happen. So hopefully we don't need to know that. But so we'll move on here to wills and probate. So if you have a will, and normally this is the point in the presentation when we do this in person where I ask people who has a will in the room, I will say that it is typically, roughly 50% of the folks will reach out and say that they don't have a will. So if you do not have a will, you should get one. It is the most vital part of your estate plan. A will is a legal document in which you direct how your property will be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, the will let you name a guardian for minor children. You can also create a trust with your will. So that's not a living trust like we talked about before. It's a what's called a testamentary trust. So it gets created upon your death. To be valid, your will must be in writing and it must be signed by you. Your signature also must be witnessed, although the required number of witnesses varies from state to state. These requirements are important because if you aren't careful, your will may be determined to be invalid. I typically recommend that you see an estate planning attorney and have them help you make out your will. It will cost you a few $100s, but it is a few $100s very well spent. Now, there is one very big consideration to having a will for most people, and that is the fact that wills have to go through a process called probate. So let's take a little bit of a look at how probate works. So most wills have to be probated. The rules vary from state to state, but in some states, smaller estates are exempt from probate or will qualify for what's an expedited process in the state of Ohio. It's called administration. So probate starts with someone filing the will. So basically you pass away, someone's going to go down to the probate court and they're going to file your will with the court. The court will then oversee the estate settlement process. Usually the person named as the executor in the will do this. Once the will is filed and validated, meaning the court takes a look at it and makes sure that it was appropriately signed and witnessed, then the executor can go about the business of settling the estate. One of the other steps that'll take place in here is that the probate court will make sure the executor wants to serve as the executor and is able to serve as the executor. If they are not, or they don't want to, the court will appoint someone else to act as executor. That person will then go about collecting any monies that were owed to you, such as wages or pension payments that were still outstanding. They will pay any outstanding bills that you still had laying around. They'll file a final income tax and estate tax return, and then they'll distribute the remaining property to the people spelled out in the will. Usually, in the vast majority of cases, everything goes fairly smoothly, and that probate process can last anywhere from a few months to a year, depending on the size of the estate. So the more complicated, typically the longer it takes. Now, if your estate ends up in messy battles and things like that, it can take multiple months and years. But a lot of times people want to avoid this process. So let's talk about why. So before we look at the reasons why you may want to avoid probate, let's look at the positive aspects of probate. For most estates, there's usually very little reason to avoid it. The actual time and costs are modest, and it just doesn't make sense to plan around it. There are actually a couple of benefits from probate. Because you get a court supervision for the process, you have assurance that your wills are going to be abided by. And if a family squabble should arise, the court can help to solve the matter on your behalf. Further, probate will offer some protection against creditors. As part of the probate process, creditors are notified, typically through an ad, to make their claims against the estate in a timely manner. If they don't do it in a timely manner, then they have a very difficult, if not impossible, time trying to collect later. However, for some complex estates, probate can be burdensome, taking sometimes 2 or more years to complete. This can tie up property that your family may need immediately, and also can increase the costs that can arise, such as executor fees, attorney's fees, insurance, court costs, all those kinds of things. And if you have real estate in more than one state, for example, if you own a summer home in Ohio and you own a winter home in Florida, for instance, your executor will have to file in every state where property is located. That's referred to as ancillary probate. And last but not least, wills and other documents that are submitted for probate are part of the public record. So anyone can walk into the courthouse and see those records, which many people are upset about. They'd rather keep those private. If any of these issues are a concern to you, an estate plan can be designed to limit the assets that pass through probate, or they can avoid probate altogether. The major ways property is passed outside of probate are, as we talked about previously, owning assets with rights of survivorship, ensuring that beneficiary designations are completed on the assets that allow them, like for instance, IRAs, retirement plans, life insurance, annuities, etc. You can use a trust, or you can make lifetime gifts. Now, let's switch gears a little bit and we'll talk about estate taxes. There are 3 types of federal taxes that may be imposed when property is transferred from one person to another, either during your life or at death. These are referred to collectively as transfer taxes. They are the gift tax, the estate tax, and the generation skipping transfer tax. We're going to discuss transfer taxes on the federal level only, of course, because the state of Ohio does not have an estate tax, so we don't have to worry about that. Or they don't have an estate tax anymore, I should say. If you, now you're referred to as the donor, transfer property to another person, the donee, during your life, the transfer may be subject to a gift tax. The reason there is a gift tax is to prevent individuals from avoiding estate tax by simply giving all the money away before they die. The gift tax does not apply to every lifetime gift, however. For example, in 2021, you can give up to $15,000 to as many individuals as you'd like, gift tax free, under something called the annual gift tax exclusion. By the way, that $15,000 figure is for 2021, but this figure is indexed for inflation, so it does occasionally go up. In addition, each individual has a lifetime exclusion from all transfers. So think of that as the money that you pass along during your life and at death. And that amount is $11.7 million in 2021. That's the largest exclusion that has ever been allowed in the history of the federal gift and estate tax. And I will tell you, I've been doing this for almost 18 years, and that number has been everywhere from 0 to 11.7 million, and not in order. So it does change based upon the current tax law and where Congress sets that figure. So when property is transferred at death, it is generally subject to the estate tax. This is true whether or not property goes through probate. For example, even though funds in an IRA will pass by virtue of a beneficiary designation, they are still potentially subject to estate tax. So they're included in that $11.7 million figure. As with the gift tax, there are exceptions to this. For example, property that you leave to your spouse is generally not subject to estate tax because there's a full deduction allowed for marital transfers. A similar deduction is available for property left to a charity. In addition, as discussed on the previous slide, each individual has a lifetime exclusion from gifts and estate taxes combined, which is $11.7 million. To be clear, there is one exclusion of $11.7 million that covers both gifts and estates. So any portion of the exclusion you use for gifts is not available to your estate. I know there will be questions on that, so if you have any, put them aside and we'll talk about them at the end. There's a new feature of the lifetime exclusion that is potentially very important for married couples. That exclusion is portable. That means that any portion of the exclusion that is not used by a spouse can be transferred to the surviving spouse. So in prior years, that was not the case. So married couples with large estates had to do what is referred to as bypass planning, typically using a trust. But for 2011 and later years, that planning is not necessary for transfer tax purposes. There are still good reasons for some people to use that bypass trust, but that's a little bit more complicated than what we're going to get into tonight. Suffice it to say that together, a married couple can pass along $23.4 million tax-free as long as the estate of the deceased spouse makes the proper elections on the estate tax return. That's a lot of money, and it only applies to roughly 1 or 2% of the population, just FYI. The third piece of the transfer tax system that we need to mention is the generation skipping transfer tax. This one is a little bit more complicated and it doesn't come up very often, but we want to touch on it. In the world of estate planning, someone who is more than one generation below you, so for instance, a grandchild or a great-grandchild, is referred to as a skip person. If property is transferred either during your life through a gift or at death to one of those skip people, then the transfer is subject to a generation skipping transfer tax, which is imposed in addition to the gift or estate tax. The reason there's a generation skipping tax is to prevent individuals from avoiding estate tax on the skipped generation, on your kids or whomever. So because the generation skipping transfer tax is a separate tax, you get a separate exemption. The exemption is $11.7 million. That figure probably sounds pretty familiar in 2021. Unlike the gift and estate tax exclusion, however, it's not portable, meaning your spouse can't use the unused portion of yours. So you don't get that full 23.4 million for spouses like you do with the estate tax. Some key tax figures are adjusted each year for inflation. So you can see here how the exclusion and the exemption amounts have changed over the last couple of years. The Tax Cuts and Jobs Act, signed in December 2017, doubled the gift and estate tax exclusion amount to 11.18 million in 2018 and 11.7 million in 2021. After 2025, they are scheduled to revert to pre-2018 levels, and they'll be cut by about half. So keep that in mind. If you've got a big estate and you're close to death, you want to do it before 2025. So another strategy is making gifts during one's lifetime. This can help to minimize transfer taxes, and in fact, transferring properties to your heirs during your lifetime has some advantages over waiting until you die. For one time, making lifetime gifts allows you to have the satisfaction of seeing those recipients enjoy that money before you're dead. For many people, though, that gifting is used to minimize transfer taxes. As I mentioned earlier, you can take advantage of the annual gift tax exclusion, which lets you give up to $15,000 to as many people as you want, gift tax free. There are several other gift tax exclusions and deductions you can take advantage of. In addition, when you gift property that is expected to appreciate in value, you remove the future appreciation from your taxable estate. There is one trade-off to lifetime gifting, however. If you give property during your life, your basis in the property is carried over to or if you give property during your life, your basis in the property for federal income tax purposes is carried over to the person who receives the gift. So, for instance, if you purchased your home for $50,000 and you gift it to your brother during your life, your $50,000 cost basis, the amount that you originally used to purchase that home, will carry over to your brother. If it's now worth $1 million and he sells it immediately, he will have to pay taxes on that gain. If, however, you were to leave that house to your brother upon your death through a transfer on death, which is bypasses the probate process, then his cost basis in that property when he inherits it will be the value of the home at your death. That's what's referred to as a stepped up cost basis. So if it was worth $1 million when you die, he inherits it. His cost basis is $1 million. And if he sells it immediately, he would not owe any taxes on that. So there are some advantages to hanging on to highly appreciated assets and passing them on upon your death. So I used a house as an example, but this also applies to things like stocks and bonds, anything that's a tangible asset that you pass on to your beneficiaries. What I mean by tangible, anything that you own, as opposed to like for instance cash or something like that, which of course does not have an appreciated value. So remember that the annual gift tax exclusion lets you give $15,000 to as many individuals as you want, gift tax free in 2021. If you and your spouse make gifts together, you can double that amount and give $30,000 to as many individuals as you want. If you're contributing to a child or grandchild's Section 529 plan, that's a college savings plan, you can give $75,000 in 2021, gift tax free, though you have to report that gift over a 5-year period. So essentially what they do is give you 5 years of gift tax exclusions that you can take all at once. If the two of you, you and your spouse, contribute together, that's of course $150,000. So certain conditions apply to this. So be aware that if you would die during that 5-year period, a portion of that gift would be included in your estate. In addition, there is no gift tax imposed on any amount gifted directly to an education institution for someone's tuition. There are also no gift taxes imposed on any amount paid directly to a medical care provider for an individual's medical care. That includes payments for health insurance. Now, one caveat on both of those payments have to go directly to the university or directly to the healthcare provider. So for instance, if you've got a grandchild who's going to college and you want to help pay for that directly, you can't write a check to your child to pay the tuition for your grandchild. You have to write the check directly to the school in order for that to fall outside that gift tax exemption. If you aren't inclined to make outright gifts, however, you may consider using a trust. So trusts, we usually again get a lot of questions on. So I'm going to kind of run through the trusts a little bit here, but again, save your questions at the end. We'll talk about them. There we go. A trust is a common and versatile estate planning tool. We've already seen a trust can play a role in planning for incapacity. We talked about that with the living trust and in avoiding probate. In addition, you may want to use a trust as part of an overall strategy in order to minimize transfer taxes, to have certain property managed by a professional, and to provide for minor children, elderly parents, and other beneficiaries. Certain trusts can be established to protect your assets from future creditors. And most importantly, trusts can provide a means to administer property on an ongoing basis according to your wishes, allowing you to maintain a certain degree of control even after you pass. Some people call this control from the grave. So what is a trust? A trust is a legal entity where someone who's called the grantor, that would be you if you write the trust, arranges with another person who's called the trustee to hold property for the benefit of a third party who's called the beneficiary. The grantor picks who the beneficiary and the trustee are and establishes the rules that must be followed in a document known as the trust agreement. When you create a trust, you split the ownership of the trust property. Legal ownership goes to the trustee and beneficial ownership goes to the beneficiary. That means the trustee is responsible for managing the property according to the rules that are spelled out in the trust document. And the beneficiary receives all the financial benefits such as income, principal, and enjoyment from the trust property. A trust that you create while you're alive is referred to as a living trust. That's a trust that we talked about for managing property while you're incapacitated. A trust that is created upon your death, for instance, under the terms of your will, is called a testamentary trust. If you have the right to change or end the trust anytime you want to, then that trust is referred to as revocable. If the trust cannot be changed or revoked, then it's described as an irrevocable trust. FYI, a revocable trust becomes irrevocable upon your death. The reason for that is because, of course, you're no longer allowed to make the change, or no longer around to make any changes to that trust document. We're not going to go into great detail, but revocable trusts are commonly used to or to plan for incapacity and avoid probate. A trust avoids probate because the trust itself determines what happens to that property upon your death. It doesn't have to be determined by the will. Irrevocable trusts, on the other hand, are commonly used for transfer tax planning purposes and protection from creditors. Next up, life insurance can play a key part in almost everyone's estate plan. For example, if you have a small or a modest estate, life insurance can be used to create an estate. So in other words, the life insurance proceeds will be the primary financial resource for surviving family members, at least until they're able to access other financial resources. This is the common need for someone who dies young and has young children at home and a spouse, and maybe they're still in the middle of their earnings years. Life insurance can also be used to provide liquidity for your estate. So for instance, if most of your net worth is tied up in the value of a business or in real estate, your heirs may need liquid money to pay for your final expenses and pay off creditors at the end of your life and things like that. And life insurance can provide that liquidity while they're working on settling the sale of a business or settling the sale of that real estate and so on and so forth. You need to be aware, however, that the general rule is that life insurance proceeds will be included in your estate for the purposes of estate tax. Now, recall that in the beginning of the presentation, I made clear that we're only talking about taxes on the federal level, and it may be different on the state level. For those of you who live like I do in the state of Ohio, that's not necessarily a concern. Although the general rule is that life insurance proceeds are included in your estate, an estate plan can be structured to exclude life insurance assets from your taxable estate. The key issue is ownership. A common strategy to avoid estate taxes on life insurance uses a trust to own and hold the policy. Such a trust is commonly referred to as an irrevocable life insurance trust or an ILIT. If the ILIT owns the life insurance policy, the proceeds of the policy will not be included in the estate for estate tax purposes. However, this is only true if the strategy is correctly implemented. Ultimately, you'll need to work with an experienced estate planning attorney if this strategy is of interest to you, because you want to make sure you do it right. Let me give you a basic idea of how it works. You create an irrevocable trust, name someone as the trustee, and name beneficiaries. The trustee will buy a life insurance policy on your life. The ILIT will be the owner of the policy. You will gift money to the ILIT. The trustee will notify the beneficiaries that you've made gifts to the trust. The beneficiaries do have a limited window of time during which they can withdraw that cash, but they don't want to, because what's going to happen is that cash is going to go to pay the premiums on the life insurance policy. Now, at your death, the ILIT will receive the proceeds of the life insurance policy. If it's been properly implemented, no estate tax will be due on the life insurance proceeds, and the funds are distributed according to the terms of the trust. The beneficiaries of the ILIT will receive the funds free of estate tax. Like most trusts, irrevocable life insurance trusts are an advanced estate planning strategy. I've tried to give you just a very basic understanding of how they work. So this is definitely something that if you want to learn more about it, come talk to me, talk to an estate planning attorney, and get the help that would be required in order to implement that. So as we take a moment to wrap up, ask yourself a couple of questions. Do you have a plan in place in the event of your capacity? Do you have a will? If the answer is no, then I highly encourage you to take care of this as soon as possible. And again, I recommend that you see an estate planning attorney. You can download documents from the internet to take care of these things, but in my opinion, it is well worth the little bit of money that you would pay in order to have an estate planning attorney handle those things. So thank you all very much. Please, again, feel free to reach out to myself or one of the other financial advisors who works within the credit union at your local member center, or I can be reached at the corporate office, which is where I work out of. All of our contact information is available on the website, and we'd be happy to answer any questions that you may have. Thank you for your time, and have a great rest of your evening.